Hi, Brian Parker from collectionstopper.com. Here are everything you need for taking care of yourself when a debt collector is chasing you. We're going to go back to debt collectors today. This one's going to be about a company called Portfolio Recovery Associates. We call them PRA. So if you're just going to hear me say PRA the whole time. But PRA is the focus today. Who is PRA is the name of the video. And again, this video is being given under the prism or the auspices of just trying to help you, giving you information, education, and a little bit of entertainment. I'm going to get right into this because I got to stop doing like 45-minute videos. I'm going to try and keep it under 30 today. When you take on a large company like PRA, understand that's a publicly traded company, so that has a door that swings both ways. A lot of these companies aren't publicly traded, so corporate enterprises and perception and optics don't work with your basic debt collectors or collection law firms. They're not really concerned what the public thinks of them unless they're doing something really unusual. Corporations are corporations, and PRA is a corporation, publicly traded, has responsibilities to shareholders, etc. So I believe the way they handle these things are quite okay, and it's reflected, I think, because of their corporate governance. I've never had a problem with PRA. In Michigan anyway, there are two firms that handle PRA, and they both are very pragmatic. Similarly to Midland Credit, which is also a publicly traded company, at least the umbrella company, they have their own in-house lawyers, and then when it gets too much, they send out to specific law firms, but they're all being authorized or listening to one master, if you will. And that personality is one of pragmatation, and you can get these cases settled pretty easy. At least I do, and I hope you do too. Let's get going. I want you to think of the concept of, like I've mentioned previously, bricks and walls. Let's look at the first exhibit. Sound like we're in court? Page 1 and page 2, Shazam, are the average complaint, at least in Michigan, and there's no reason to change. This is an account-stated lawsuit in the 15th district which is Ann Arbor, Washtenaw County. Going back to our last video, this is not a federal case. Anyway, back to state cases. It's a basic fill-in-the-blank everyday template that I see no matter what lawyer brings the lawsuit against my clients. And what I've advised you to do, as I advise you here, is take the 2 pages, rip them apart, and then either on the left of each paragraph, if it's true, if it's false, false, if it's true, true, and then figure out what you're going to do about the true, which is very rare. Other than usually, yeah, I do live there. That would be true. But look for that. 10% of my cases, they file them in the wrong district, and that's money for my clients. In this case, supposedly PRA has bought a debt from, if you look at page 2, Shazam, you'll see page 2 that they claim that the PRA bought and sold something from CIT, online bank, to plaintiff. Remember that. And it says, see attached bill of sale. Remember that. And then it goes on in paragraph 7, that plaintiff, PRA, through its assignor, and not mentioned, and defendant have consented to a sum as the credit balance. So that's setting you up for what we've talked about as an account stated balance or lawsuit. And plaintiff is obviously PRA through its assigner, what we learned from the first paragraph, that's CIT Online Bank. So remember that. Again, this is a basic PRA, seeking an amount of money, which in this case is Weber and Olsey, which are very easy to deal with. The bill of sale in the PRA case is something you need to look at. That is on identified as page 2. And if you look at page 2, that's the bill of sale. Here it is, but boom, on the screen, Shazam. Fun things to look at. Look at the very top of it. It says the master account purchase agreement between Dell Financial Services and Portfolio Recovery Associates, PRA, governs this whole thing. They're doing it through what's called all bill of sales with debt collection. When a debt buyer is involved, they do it through what's called a master account purchase agreement or a forward flow agreement, a sales forward. They have these fancy names for the same thing. It's this general all-encompassing deal that in this case, Dell, who by the way was not mentioned, you just heard me say it was CIT Online Services. Dell has a deal with PRA, and subsequent sales will be made through the master account purchase. Your first question is, where's that in the bill of sale? Where do I see this if it's governing this whole thing? You won't. It's a real hard case to get that stuff. I've got these things, but they'll usually settle. So that's a touch point for you. If you go for this master account purchase agreement, they don't like that. So if they give you a hard time, go for that. It's right there. They're saying this is all based upon this. Some things to note. On page 2 on the screen at the bottom, you'll see the bill of sale excused without recourse. What the heck that is? And without any representation or any warranty of collectability or express or implied warrantability or collectability except as provided through the account purchase agreement. What does all that mean? It means it's an as-is sale. We're not guaranteeing or warranting collectability. Well, that tells you right there that the purchaser is buying crap that has no... It's like buying a used car as is and just taking your chances. Sure, it's got 100,000 miles on it. I'm sure it'll be fine. Do you guarantee that? It's as is. So every purchase from here on out is an as-is sale. Y'all know what that means. So there's no warranty. There's nothing with the seller, which they claim to be Dell Financial Services, is saying, look, this is all yours as is. So think about that as far as it be of any value or truth to what they're claiming you owe, or if they even own it. This sale file, they have a page, or I have a page 3. If you look at page 3 on the screen, and it's, well, first off, you know something's up here because I'm not OCD or anything, but look at the bill of sale. It's on the side. If this is a really serious document that's really a bill of sale, you'd think at least it'd be a little cleaned up a bit. Now I've added some stuff that I want you to look at. Look at my underlined DFS as designee for revolver. I guess Dell Revolver Company is also involved in this, as is Dell Financial Services, as is Web Bank. Who is Web Bank? They have not been mentioned in the lawsuit, but who is CIT that was, but isn't in any of these bill of sales so far? So let's keep going. The bill of sale, again, claims that the original creditor is Web Bank here. That ain't true unless it is, then CIT Online isn't, as it says in paragraph 6 of the complaint. Look at page 4, Shazam page 4, and that's an Exhibit A1 to the bill of sale, which names the data file that my client, this is a 3-year-old case, a 3-day-year-old case. I just got this and I've already answered it. In this case, my client has a data file where his debt is inside of it, according to the bill of sale. The purchase accounts are charged off accounts that are included in the electronic file, and it has a data extension of XLS. That's just PDF or .net or .com. So we're led to believe that that was conveyed to Dell Financial Services. Now, they're not mentioning Revolver, as they just did as part of the bill of sale, or as Dell Financial Services being a designee or anything like that. And by the way, there's no signature. There's no signature on page 4. These are referenced. Purchase accounts were sold, assigned, and delivered and transferred. And again, as I said, they do not have any representation. But my point being, if you look at page 5, same thing, this is Schedule 1 to the bill of sale. Again, they have a data file. Let's put page 5 on the screen, Shazam, and you'll see they have a data file where supposedly the client's debt is .xls. We then go to page 6, which shows you the actual sales file they're claiming represents holding the debt. But there is missing the data extension. The data extension is everything. It's like saying, I'm going to go find Parker's website at Collection Stopper and then not putting .com. Ain't going to happen. So why, if they're writing all this document, would they go so far as to put the whole complete file but not the data extension? Because I suspect none of this is true, especially when you consider the bill of sale has the wrong creditor, or the right one, and the complaint is wrong. So when I call this thing bricks and walls, these things I'm showing you are material issues. Who is the original creditor is a material issue. So some of these are bricks, some of these are walls. Who the creditor is a wall, or a lot of bricks heading towards a wall against you being found liable for this debt. And again, look at page 6, the extension, the data extension is missing. Without the data extension, you don't have the existence of a file. It's plain and simple. It's like me saying, again, go to Collection Stopper and not telling you the last data extension. Page 7 is the most fun I'm going to have in this video with PRA. This is your average PRA affidavit, all right? And as you know from my many videos, especially the one I just did on Solo Suit, where they just they would totally ignore the most important document, which is the account stated counter affidavit that I ask all my clients to sign and file based upon the facts and law at the time. And if you look at page 7, Shazam, you'll see this is your average run-of-the-mill Commonwealth of Virginia, City of Danville affidavit. So when a company, a quick lesson again, does not have proof of the original contract, they are allowed to bring in an account stated affidavit as they've done here. So let's take a look at this. This is a person, Angela Murphy, saying she's competent to testify in the matters herein. Always look for the flowery legal language as a tip-off as to how unlegal things are. It's more weeds than it is flowers. That's pretty funny. Anyway, here it says the business records were transferred from an online bank, CIT, to the account assignee, Dell Financial Services. I've got a little asterisk there. Well, okay, so records were transferred, but there's no assignment, there's no transfer of the debt, there's no indebtedness going over, they're just records. So I'm going to look for paragraph 3 to tell me, yeah, there's an assignment. And according to the business records, which are maintained in the ordinary course of business, the account, there's nothing about an assignment, just, well, they do have something that all of the account seller's interest in such account having been sold and assigned and transferred by the account seller, which in this case we're led to believe is Dell Financial, no mention of CIT. And then from there on in, people are called account sellers or account assignees without any reference to a couple of things. Where are the other members in the bill of sale? Because this person has signed an affidavit saying she has personal knowledge of the entire records. She's saying she has personal knowledge because under your state evidence rules of hearsay, the general rule, hearsay, this is imprinted in my brain from law school. I had to keep saying this for weeks just to make it stick. And it's an out-of-court statement offered to prove the truth of the matter asserted. Hearsay is an out-of-court statement offered to prove the truth of the matter asserted. So someone says, I own these things. That's a true statement if they can back it up in court. Outside of court, I guess it's just someone saying something. Inside, it's hearsay. I heard said. And that is a hearsay statement, an out-of-court statement offered to prove the truth of the matter asserted. And that should be in court. So they have to lock up somebody here saying, yep, I got personal knowledge, I know what's going on, even though I'm not mentioning half the stuff that the contrary bill of sale is saying. Contrary meaning web bank is not mentioned in this affidavit, even though the bill of sale states specifically that web bank is the original creditor. So it's already a mess. And it was a mess from day one. Here's some tips for your affidavit. I'm going to drop these. So, number 7, this is some real good stuff. How to handle a PRA affidavit. Always look at the signature of the person. This seems okay. You wouldn't believe how many I see where there's just normal formatting and then the signature has dots all around it, or has just kind of slanted to the left, or is a perfect signature but not on the line that it's signed on. That's either a cut or paste or what's called a robo signing. So always look at the signature, but then I want you to look up the signature. The person's name, in this case is Angela Murphy. You can just Google Angela Murphy, custodian of records, affiant, affidavit, PRA, and the wildest stuff comes up. I've done cases where I've pulled signatures of the affiant, that's what the person that signs an affidavit is, that are completely different from the one here. And what do? I make a detailed account affidavit where right in the affidavit, just go online at collectionstopper-extension.com, podcast plus section, and you'll see all my either affidavits from debt collectors or my affidavits where I'm going, hey look, that's a phony signature, here's why. So this looks pretty squared up. I don't see any dots. I haven't looked up her name. I had so many other reasons to win this, I didn't need to go deep. Sometimes it's fun to go deep. But we look to see, is it grainy? Is it a different format than the rest of the language? Is it signed on a straight line? Or is it off? It's straight, but it's not on the straight line. How'd you do that? Well, you cut and paste. You can see it, man. It's real easy to point it out to the court, too. Look at the notary. She's notarizing. She said, this person sat in front of me. You wouldn't believe how many times I found the notary saying, yeah, she's in Virginia and she's on vacation that week. Just go to Facebook. Or Google says she doesn't even reside in Virginia. She's in Utah. You're going, am I really looking at that? And then you feel your heart and it's going a mile a minute because you're like, oh my God, my subconscious is seeing what my conscious, a huge corporation takes risks like that. And it's not in this case, but they do that. Look at the date the affidavit was signed and notarized to find out both were the two people in the same room as they're claiming to be. She's supposed to, yes, subscribe and so on to before me on April 10th. Good thing about the date in Michigan, the account state of Michigan says that date has got to be within 10 days of the filing of the lawsuit. And that's the case in many states. There's sort of a window you have. And that's all about, again, showing a document that is generally hearsay has credibility. The closer it has to the filing of the complaint, I guess it's better. In this case, it's over 2 months. And that's against the law under the account stated statute. And you could probably say it in your sleep, because I say it so many times if you watch my videos. MCL 600.2145. That thing is chock full of good things I'm going to be doing with it soon. Some things to look at. Is the account number correct? You'll be so surprised, maybe not after all this, how the account number is not the same as what the client has on their account statements. We're looking at hearsay again. Does it meet the business records exception to the hearsay rule? The general rule is, what's hearsay? An out-of-court statement offered to prove the truth of the matter asserted. This was signed out of court, and it's being offered for the truth that the client owes the debt. So it's not coming in generally. The exception is if it meets the business exceptions rule. If you are in federal court, which you're not, and just go to my last video, it would be 8031 is hearsay, 8031 FRE 8031, FRE 8036 is the business records exception, meaning it comes in if it meets certain criteria under the business records exception. In Michigan, it's MRE 8036 is the business records exception. So what I would recommend you do, and that's why you see so many things like, according to the business records, that's why they're saying that, which are maintained in the ordinary course of business. The account and all proceeds of the account are now owned by the account assignee, without saying who that is. So they use these flowery words, which are really weeds, but they think legal words means, yep, we qualify for the business records exception because we use the word business records. They have to have personal knowledge. And how that is said shows you the level or the degree of personal knowledge. Sometimes they got to cover themselves because they don't have as much as they have. And you'll see tons of descriptive words and things that make no sense because they're covering up or hiding something. So look for the hearsay and the hearsay exception. I would recommend you take the business records exception, print it, and then line it up with the affidavit and see what the first criteria is. Does that meet it? Second criteria, it generally doesn't, but here's the rub. Courts are allowing the exception, which somebody is exceptional, they're a 1 in a million, or they're better than everybody else. Exception means is the opposite of the general rule. But courts are allowing, check this nice line out, they're allowing the exception to swallow the general rule. You can use that. And they are. Everything comes in. And in Michigan and other states, they're allowing custodian of records that would normally have to come from New York or wherever Citibank or wherever it is and have to appear in Podank, USA, maybe Michigan County. To stop that, they've passed laws that say the person doesn't have to show up as long as they sign something saying they have personal knowledge of the records being entered for the truth of the matter asserted. That's part of the maintaining sort of a hearsay exception. In Michigan, it's MRE 911, 912, and I'm sure it's similarly in other states. But as I said, make them earn it. Make sure your affidavit says no. And in this case, the rule in this case under the account stated statutes, you must bring the affidavit within 10 days of the filing of the lawsuit. They didn't. So I would argue if they broke that rule, there's no exception. It's an exception to the general rule. It's clearly hearsay by their own delays. In this case, number 1, page 2, Shazam, you can see it was signed July 2023, and the affidavit here was signed April 10. Another cool thing to look at, and my point, I'm over here, is the date. Go to number 7, page 7, Shazam. The date is April. So what you've got to look for then is, was that signed before or after the complaint was filed? Well, it was signed before the complaint. Yet your client, my client, is referred to as defendant and PRA is plaintiff, which is an impossibility because the lawsuit hasn't been filed. So Parker argues, so it's a small wall, brick, not a wall. If they lied about that, they lied about everything else. And then you throw in the original creditor and then this and you can't, it all adds up pretty fast to become a wall. So measure up the exception to their affidavit and see how the two don't meet. In this case, Dell is considered an account seller while CIT is considered the original creditor, which it's not. There are parts to this that say they got it from WebBank. All right, take their word for it, because either way we're going to win this case because of the changing creditors. That's all you need, but that should all be what I just said to you. Whatever information you're able to ferret out from just your analyzing the way I said to analyze these things, you're going to find your bricks and you're going to build your wall, and it's going to be all in your account affidavit statement to the court, your counter affidavit, because this is an account stated complaint. And how do we beat those? With a counter affidavit. I think I got it under 30. I hope I did. Brian Parker here from collectionstopper.com, and go to Podcast Plus for these show notes so you don't have to look at this face again to hear this great information. I'll put the complaint and everything else right on my Podcast Plus so you can see what I was talking about slowly. As I said, compare and contrast. Compare what they're saying to reality and also what 8036. I don't think you need to go that deep. I didn't have to in this case. You better believe it's in my affirmative defenses, and it's also in my account stated affidavit. So have enough bricks to build a wall. You've got to remember you're going to have to possibly down the road, this ain't going to trial, justify your affirmative defenses because it's a form of pleadings. A thing I forgot to tell you about, and you know I'm big on talking about securitization. These lights are heating up. There's no mention of this thing being in a secured trust or an asset-backed security, an ABS. All these debts go straight there. That's how companies make money now. That's a good form and a logical way to make money with this kind of debt. Yet the affidavit mentions nothing about it, whilst where the affiant claims, I am on top of all these records, and she didn't even mention the original creditor. So my point being is, don't forget securitization. It's your friend. And it's all about the assignments, baby, of which there are several missing here. So look for that. You know what I'm going to do? I'm going to create a checklist, a hacking checklist for things that you can check off when you're looking at a complaint or the documents. I think that would be really helpful. So give me a couple of days to work that out. I'll put it on collectionstopper.com, and I will put that in Podcast Plus. It'll be a checklist. So when you get the lawsuit, you can go through, yes or no, did they do this? And it may be a good friend to you as you create the counter affidavit. The counter affidavit is everything. The assignments are second most important, and their general lies are a very large wall and doubly as important as the waning truth. All right, Brian Parker again, collectionstopper.com. Please subscribe and like and ask me comments. I go and read the comments and I answer them as best I can. So if you have any video choices you want, let me know. I'll do it. 30 years in 30 minutes. I thank you very much for your time.